I will move on to item number 6, statutes for trial court restructuring.
Okay,
Mhm.
this one is mine. This memo, I'm going to start with memo 2021-22, which is the one about reviewing the references in the codes to superior courts. That's a major project that's been on the Commission's trial court restructuring to-do list for many years. The way that the project developed was, of course, before unification, there were both municipal courts and superior courts. When the courts unified, the codes had to be adjusted to become workable in a unified court system. They were initially, because unification occurred on a county by county basis, they were first adjusted to be workable regardless of whether a county's courts were unified or not. That meant that the procedures that were used needed to be uniform across the state. And so the commission in preparing legislation to accommodate unification was very careful to preserve existing procedural distinctions between municipal and superior court cases while making those procedures workable in a unified court system. And the way that the commission went about this was to revise all the statutory references to municipal court cases, I should say, to refer to instead to limited civil cases, and to also propose a statute that defined the characteristics of a limited civil case, which became Code of Civil Procedure Section 85. And there's another provision in the Code of Civil Procedure that deals with the types of relief available in a limited civil case. So in the course of that work, the commission and then later the legislature dealt with every statutory reference to municipal courts. We looked at all of them. But we did not look at every statutory reference to superior courts. Under the Constitution, the jurisdiction at that time, the jurisdiction of the municipal courts had to be identified by statute. So every type of case that was within the jurisdiction of the municipal courts was something that was identified by statute, and then the jurisdiction of the superior courts was everything else. And so we didn't need to specifically examine every single reference to superior courts. But now that the courts are unified, the references to the superior courts aren't as precise as they used to be, because in the past, when a statute said that this is a case that can be brought in superior court, it automatically told you also that it was subject to certain kinds of procedures. Now that all kinds of cases are brought in superior court, saying that a case is brought in superior court really doesn't tell you anything about what kind of procedures it's subject to. Because of that, the commission about 20 years ago thought that it might be a good idea to go through all of the statutory references to superior court and specify whether they were unlimited civil cases or limited civil cases, although the limited civil cases are already specified. So this would be identifying things that constitute an unlimited civil case. That would be a huge project. We did some preliminary work on it about 20 years ago, which is described in the memo. It would be complex, difficult. I've given examples in the memo of some of the work. At this point, the staff needs some general guidance on whether how you would like to approach this project. Do you really want to examine, and there are about 14,000 of them. Do you really want to examine all of those references to the superior courts in the codes and try to discern whether to add some language about what kind of jurisdictional classification applies? Or would you, what we're suggesting in the memo is to adopt a much more light touch approach, where it would be essentially, no, we're not going to do any systematic review of those provisions. And we're only going to deal with them if a specific problem is brought to the commission's attention.
I suggest option B.
I agree.
Does anybody feel differently?
You lost me at 14,000.
Well, I think I'm much relieved. Let's put it that way. So I think the only other questions in this memo, did you want to hear anything further about the situations that the attorney, our former staff attorney, Lynn Ehrman, identified some situations 20 years ago that she thought potentially might raise issues. Do you want to hear any more about that, or would you prefer to just, because those have apparently not materialized to the point that somebody has brought them to the commission's attention, do you want to just let those go, and if somebody does at some point raise them, then we can deal with them at that time?
I again suggest option B.
Yeah.
But I mean, Barbara, can you give us just a cursory, like a big, like a picture view of, or did you want to? I think it's important just for the record.
Well, I mean, there are some examples given in the memo of, like the probate code cases. The probate code provisions, there's, I believe, a provision at the beginning of the probate code that specifies that they're cases that are superior court cases. And in the past, that meant that, of course, they were not subject to municipal court proceedings, and superior probate code cases are special proceedings and have never been subject even to the same procedures as regular superior court cases. Is there any need to say in the probate code that they are unlimited civil cases rather than limited civil cases? I mean, that's the kind of issue that was raised. There were various other ones similar to that, but people seem to be coping pretty well with probate code jurisdiction without that kind of guidance, and so it seems like spending the commission's time on this would be, there are other things that the commission could be doing that would be a better use of its resources.
Yeah, no, and I think too, like you said, the courts, they've already been dealing with COVID shortages and budgetary issues. I think that the courts are making do. And so we can just maybe look for comment later with the cumulative. That's okay. We can move forward.
So then the last issue in this memo was in the course of the work that Lynn Ehrman did about 20 years ago, there were a couple of technical problems that she found in the code where there were statutes that referred to having multiple courts, multiple trial courts in a county. And that's no longer true. Every county only has the superior court of that county. And so there were technical revisions shown at the end of the memo of Business and Professions Code section 6092.5 and Penal Code section 2020. And the question is just whether to incorporate those technical corrections in the Commission's next tentative recommendation on trial court restructuring.
Sure.
Does anybody have any concerns about that? Okay.
Looking, there's no, no hands, there's no issues.
Okay, well, that completes that memo. The second memo is Memorandum 2021-28. It's a continuation of the Commission's work on statutes that relate to judicial benefits. This was a topic that the Commission has already considered to some extent, but wanted further information about certain issues. And this memo attempts to provide the information that the Commission was looking for. The first issue discussed in the memo has to do with the scope of Government Code sections 69894.3 and section 69894.4. Those are the two provisions we discussed earlier that apply where it's in a county that has a population of over 2 million people. That's the key language in the statute. But that language is somewhat ambiguous because the number of counties that fall in that category, having over 2 million people, has varied over time. When the statute was first adopted, Los Angeles County was the only county that fell in that category. Later, now, for instance, there are 5 counties and perhaps 6 that have populations of over 2 million. The statute doesn't specify which census should be used in determining the county population. The legal analysis that was presented in one of the earlier memos that was done by our former staff attorney, Lynn Ehrman, suggested that perhaps the sections should be interpreted to apply where the most recent federal census indicated that the county had a population of over 2 million. Her reasoning was basically sort of an inferential reasoning, saying that sections 69894.3 and 69894.4, she actually didn't examine those particular sections, but she discussed a similar statute in the same article, and applying her reasoning to section 69894.3 and 69894.4. The idea was basically that other statutes within that article were amended to refer to a specific census. These statutes were not amended in that manner. And by inference, you could conclude that the failure to amend them in that manner was deliberate, and that therefore they were meant to basically refer to the most recent census rather than to a particular census that was in effect and that should be enumerated in the statutes. They legislative history material that we were able to obtain from state archives since the commission last considered this issue suggests otherwise. The documents are attached to the memo that we did receive, and they are pretty clear that they were intended to, that these particular provisions, section 69894.3 and 69894.4, were intended to apply only in Los Angeles County, at least at the time of enactment. And there's nothing in the materials that even references the fact that the statute was framed in terms of a county having a population over 2 million rather than having application only in Los Angeles County. So, and there is, you know, because there is this direct evidence of legislative intent on the point, that most likely would override the type of inferential reasoning that was done in the earlier staff memo. So I think based on the materials that we were able to obtain from state archives, it seems like the commission can sort of safely assume in dealing with revisions of sections 69894.3 and 69894.4 that you're really looking at what's going on in Los Angeles County. And the other point that the commission might want to consider is whether to make that explicit in the sections rather than leaving it ambiguous as they currently are. And that could be done either by referring to a particular census. It could be done by referring directly to Los Angeles County. Could be done by referring to a county of the first class. None of that is related to trial court restructuring. If the commission was to do this, it would be done pursuant to its general authority to do technical and minor substantive corrections under, I think it's section, it's under its governing statute. I think it's section 8280. I can't remember the section number right now, but the commission does have general authority to do minor substantive and technical corrections. But that is not part of its trial court restructuring mandate. And so the question is, do you want to propose that kind of clarification here? Or would it be better to just keep the proposal simple and avoid this potential issue, which might raise concerns or at least require, you know, considerable explanation at some point?
And I think if we anchor it to the census, I think it makes sense and it helps to explain what we were already kind of inferring. Richard?
My sense is that maintaining the simplicity of how it is written, which since it has worked well for these many years, should not be tampered with. What I find interesting is the fact that there is specificity to Los Angeles County, which is the only county in the state that either now or potentially in the future is going to have a population increase of any substantial amount. That is probably not likely to happen, but of course we cannot predict that. Nevertheless, if the statute works well now, as written, notwithstanding the fact that we haven't had a explosive population growth in any other county, which would make us have to reconsider, I propose that we would stay with the statute the way it is, if that makes sense, and not tamper with it to make it more difficult to interpret it would have to be. That would be my feeling. Does that make any sense?
It does, actually. Yeah. Richard Simpson?
Actually, I was going to suggest sort of Barbara's last option, which is the way when I spent 35 years in the legislature, and the reason we did that kind of thing was because the Constitution requires statutes to be applicable statewide, and when we wanted it to apply to a particular county or school district, we would use some sort of a generic description to apply it. And so my suggestion would be just amend it to be apply to counties of the first class. That's the common way that statutes are drafted these days to apply to a particular jurisdiction and still conform to the Constitution's statewide applicability requirement. So I think it's a non-substantive technical change consistent with the material you guys collected from the archives about the letter conversation in the governor's staff. So that seems to me to be to make it clear what the legislature intended back in 1950, whatever.
So cool. Those letters are awesome.
Yeah.
Jane, did you want to say something? It looks like, okay. I mean, these are good points on both ends. So I'm not sure how the commission is leaning because I think the fact that we had to spend so much time and resources in trying to understand what the rationale is, even though, I mean, I love history, so these letters are awesome. But I think that it created some confusion that was unnecessary. And I think Commissioner, I'm like looking for your last name, Richard Simpson, makes a good point because, so to the extent, Commissioner Rubin, that, if it's not broken, don't fix it. But it was broken because we didn't understand it. But we would understand it if it did say first class, so that we can, there's enough legislative history so that we would understand what that meant. And it would be tied to the census, which makes sense. And no one has to infer or guess or go through this in another 10, 20, 30 years from now. So that I would recommend that. Any other commissioners want to speak to this? Everyone's quiet. Good, Kara?
I'm still learning how all of this works, but to me, making that type of change seems like it, even though we're interpreting it as a non-substantive change, it could be perceived as a substantive change. And that's my only concern, is whether or not it would be questioned as within the commission's purview.
I think it's within that is I mean, what we could do is it would be included in our draft, and so that it would be circulated for comment. But it is within, we can make changes that lend or help the statute. And I do think it adds clarity because it is confusing. Why was Los Angeles, singled out? But it helped, then we went through all of this, and I'm not sure everyone else will go through this memo, which is, it's my favorite, Barbara, I have to say. This is a really cool one. But I don't know if,
did Barbara say that it's sort of not within the original task of the commission?
No, it is. No, that's what she was saying, that it is, that this is within our purview. We can make this change as a substantive change because it's just to lend clarity. Barbara, are you there? Yeah.
I am here. So what I was trying to explain as far as the scope of this is that this particular study relating to trial court restructuring is based on Government Code Section 71674, in which the legislature directed the commission to review the codes for material that was made obsolete by the major trial court restructuring reforms. Clarifying these provisions in the manner we're discussing is unrelated to trial court restructuring. So it would not fall within that statutory authority. But the commission does have general statutory authority, and I just found the code section is section 8298 of the government code, which gives the commission authority to recommend revisions that would address technical and minor substantive defects in the codes. So this could be done pursuant to that authority. But it is a sidelight. It's not the main focus of this particular study. And potentially a proposed revision along these lines might detract from attention on the, or detract from or complicate the main revisions that the commission is trying to accomplish in this study relating to trial court restructuring.
Just for my 2 cents, I agree with Richard Simpson's proposal. It makes perfect sense to conform to what the legislature normally does in these cases. I'm a little worried about what Kara's suggesting, because if we take the concept of not doing substantive change, even minor substantive change, as Barbara said, we're allowed to do under a separate statute, then we're just reduced to the point of being scriveners, just changing commas. I mean, I think this is the very sort of thing of a minor substantive change. Yes, it's a substantive change, but it's a minor substantive change that Barbara says is allowed. And it's precisely the sort of thing that we should be working on to clarify things, to conform with how the legislature normally handle these sort of things. So I'm all for what Richard's proposing.
I guess I wasn't trying to imply that I don't think it should be done. Is there a different means that we would be able to do it so it doesn't detract from this proposal is all I was saying.
No, it's a good point, Kara.
And I apologize. I actually have to run. I have another meeting, so I apologize. I was going to try and stay through this one.
This was a good point, and we're almost done. So you'll read, but thank you.
Thank you.
Okay, bye-bye. You guys, we have good questions. Barbara, oh, you have something further? Go ahead.
Well, I'd just like to say that I think this wouldn't really, I mean, partly at this point, we're not even at a tentative recommendation. So certainly testing the idea through a tentative recommendation is not likely to really harm the commission's proposal at this point. And I also think with regard to these trial court restructuring proposals, in general, our manner of handling them when they get to be bills in the legislature is that if any particular proposed revision creates problems, it tends to be easy to just amend the bill and jettison that particular proposed revision and proceed with the remainder of the bill. And it tends not to jeopardize the entire enactment is our experience.
Any questions from anyone? So how are we going to proceed, you guys? Commissioner Carrillo, you're not going to make a motion, really?
I'm generally in agreement with the approach that Rick and Victor are expressing, and that's consistent with my general theme that, you know, the muni courts have been gone since the mid 90s, and so, like, you know, under my general rubric of let's do what we can without going to the level of making 14,000 individual changes, but let's do what we can to, you know, recognize reality. And, you know, and I do recognize that, you know, in a lot of instances, everybody knows the reality that the muni courts are gone. And, you know, there's these sort of like dead, defunct sections, and everybody just sort of ignores them and moves on with their lives. But to the extent that we can make suggestions that the legislature, you know, adopt changes that would clean up the law, I think that's our core function. And they can always say no.
Can I ask Richard, since, you know, it's your proposal, if you could make the motion, Richard, you probably state it more.
Yeah, state it and then I'll move it.
Sure. I will move that we recommend to modify the the reference in those two code sections from counties with a population of over 2 million to counties of the first class.
I second.
Pursuant to, and there's a government code section that defines the classes. I don't remember what that is, but Barbara knows.
Second.
And we could even say pursuant to our authority under the code, the statute, what is it, 8580? Barbara, what was it?
It's 8298, and we could refer to that in the commission's report so that it's clear what authority we're relying on in proposing that revision.
Yeah, I like that.
Barbara and I haven't talked about this, but it's just something that occurred to me listening to the conversation. The other thing is if we have a collection of things that aren't clearly within the trial court restructuring authority, we could put together a separate tentative recommendation for just technical revisions.
Sure.
And if there's support for that and it turns into a final, then we don't necessarily even tie it to our proposal in the legislature. We could offer it to Leg Council if they think it's clear enough, or to the Judiciary Committee for inclusion in an omnibus bill.
Yeah, no, that sounds sounds fine.
Yeah, I think that'd be a much cleaner way of dealing with it.
Yep.
It would be, except that you need to consider the other issues relating to these particular sections, and if there are other changes that you want to make to those sections, then I think you need to put it in the trial court.
I agree with you.
Well, why don't we just make the motion that we are in favor of it in the generic sense? As to the actual mechanism, that's going to be up to circumstances and the staff.
I second that too.
Sure.
Yeah, but Barbara does make another point, because it requires just another study, a follow-up study, just to make sure that it's not creating an issue with others.
Well, regardless of the vehicle, eventually it's going to say first class.
Yeah, no,
Yeah. So
And
just a
for
narrow
now,
decision on the merits to be implemented as appropriate later in the study.
Yep.
Right.
Okay, I think, are we all in agreement?
Aye.
Okay, any abstentions? Okay, anyone in opposition? No. Okay, good. Good, Barbara.
Okay. The next section, this is actually continuation of discussion of section 69894.4, also one we discussed to some extent last time. And this is the one relating to travel expenses and reimbursement for travel expenses of court and personnel. And last time we discussed how the commission had initially proposed to repeal this section back in 2001. LA Superior Court objected to the proposed repeal because they felt that the portion of the section that relates to assignment of an automobile was still important to retain, but to substitute the court instead of the county as the entity that would determine whether assignment of an automobile was appropriate. Then in the memo for the February meeting, the staff again proposed to repeal the section, this time because the Judicial Council has since adopted various policies relating to travel expenses, which did seem to cover the assignment of an automobile. LA Superior Court objected to that. They still contend that this section is important to retain, at least the part with respect to assignment of an automobile. Their initial comments on this topic didn't really say why they felt it was so important to keep this provision, although they did say that the statute provides greater clarity than the Judicial Council policies. At the last meeting, the commission directed the staff to try and obtain more information from Los Angeles County Superior Court about their position on this particular section, which I did. And we were lucky enough to get a response from the court which has been, which I think is very helpful. And they have made clear that they would not object to amending the statute as shown on pages 11 and 12 of the memo, which is essentially implementation of the approach they suggested back in 2000, the idea of amending the statute to remove everything except the part of it that relates to assignment of an automobile, and revising that to apply to give the court rather than the county the authority to decide whether assignment of an automobile is appropriate. And so that I'm seeing a hand from Commissioner Simpson. Maybe I'll stop there.
I was going to say, I think your suggestion is fine, except that it should say in each county of the first class rather than counties over 2 million. Other than that, I would recommend we go with your suggestion, the amendment rather than repeal.
Commissioner Carrillo?
Yeah, I second that. And I am super happy that we decided to reach out and ask. And I'm even more happy that they came back and answered us. And of all, they said they agree with us. So that worked out really well.
That is pretty rare, honestly. I don't know how.
We were debating whether it was even worth asking, and look, it worked out. That was awesome.
Well, that, and I think we should be, really thankful to the court for taking the time to respond. I mean, these are important questions affecting the courts, but they've got so much going on day to day, especially with the pandemic, that it's hard to get them to focus on these things that aren't an immediate impact on the courts, but they are important.
I'm going to do a shout out to the Downey Courthouse because I did tell them to pay attention to your updates. I'm glad to hear this.
Okay, so is that unanimous then that we'll go ahead with? I'm not seeing any objections to that. Okay. So then the next question relates to the other statute that applies to a county over 2 million population. And this is one that the commission also partially discussed in February and determined that the parts of it relating to benefits for judges and for jurors should be retained. The LA Superior, we just didn't discuss the remainder of it in February, but LA County Superior Court has been very clear that they consider the entire provision to be of continuing importance. And so the staff's recommendation with regard to section 69894.3 was to leave it entirely alone, except that now we have decided to revise it to apply to a county of a first class. And so I guess, the idea would be to just make that technical revision, but not any other revisions of that particular section. Yep. That's what the commission would like to do on that one?
Yep, it's a bunch of heads nodding, yes.
Okay, all right, so now we're on page 16 of the memo. This is section 53200.3 of the government code. It's a statute that it's in an article entitled County Group Insurance, and that article authorizes local agencies to arrange for their officers, employees to obtain group health and welfare benefits. And section 53200.3 extends that authority to court personnel in specified circumstances. And this particular provision, we're now beyond the ones that are limited to a county of population 2 million. This is a statewide statute. And in 2001, the commission proposed to repeal this section. LA County Superior Court objected, said that it was still useful. Since then, it has become clear through the Sturgeon line of cases and the related legislation on that, that the provisions relating to judicial benefits are still important. LA Superior Court has also made clear that they consider the statute important, not just with respect to judicial benefits, but with respect to benefits for other court personnel as well. And so as far as completely repealing the provision, it's pretty clear that that would be objectionable to LA County Superior Court. They consider it important. However, the provision does apply with regard to both superior courts and municipal courts. And so that this raises the same set of issues that the commission discussed to some extent before about what to do with the municipal court reference. There are still retired municipal court judges and their families who may still be collecting benefits. And so it's possible that this provision still is important to them in some manner. The memo discusses basically 3 possible options for proceeding with respect to this one. One way would be just to leave it in the codes as is. Don't do anything about the municipal court reference, leave it to somebody else to do that cleanup later on. Another option would be what I've called the belt and suspenders approach, which would be to have a 50-year sunset clause like we discussed at a previous meeting, coupled with a saving clause, which we've already decided should be part of the commission's proposal anyway. And then to refer to the saving clause in the comment to the provision that would add the sunset clause. But to implement that kind of approach with respect to this provision is somewhat more complicated than some of the other provisions the commission considered, because here you would have to have 2 sets of the statute on the books for approximately 50 years. One that would be operative until 50 years have elapsed, and one that would become operative when the 50 years elapse. So that's the second option. And the third option would be simply to delete the municipal court reference now, rely on the saving clause, and refer to that in the comment. So Commissioner Carrillo?
I suggest option 3 because it's effectively a grandfather clause. So what it does is it deletes all references, but saves anybody who has a current vested right. So just in case there are still a few old muni court judges still floating around, no disrespect, they're entitled to their benefits. No one is intending to cut them off. So not only by including a specific saving clause in the statute for anybody who currently has vested rights, and then explaining it in the comment, that should protect all those people.
Go ahead, Simpson.
What does it remind me what a savings clause says? And the only reason I'm asking is if the problem we're trying to solve is having the term municipal court still in the law, I'd want to make sure that if there's a court decision about this some years down, someone didn't say, well, okay, the legislature obviously was intending to change something because they changed the law. I'd want to make sure that whatever the savings clause was clear enough that that this really wasn't a substantive change in who is entitled to benefits and for what period of time, that this was simply, I mean, really, the problem we're trying to solve is the term municipal court in the law is annoying. And so I want to make sure I'm not creating a potential problem simply because having municipal court in the law is annoying. So
Barbara, I assume we'd be looking at some draft language.
Yeah.
Yeah, I'm looking through the memo to find, I
That's
thought
okay.
I had quoted the saving clause. There is, oh, here it is. Yeah, so this is when the commission did its initial work on trial court restructuring, it proposed repeal of many court employment statutes in the big bill in 2002. And there was a saving clause in that bill. And that savings clause is exactly the same language that we would be considering using here. And we've also used similar language in another commission proposal.
Okay.
But it's in footnote 8 of the memo on page 3. It says, if a right, privilege, duty, authority, or status, including but not limited to a qualification for office, salary range, or employment benefit, is based on a provision of law repealed by this act, and if a statute, order, rule of court, memorandum of understanding, or other legally effective instrument provides that the right, duty, authority, or status continues for a period beyond the effective date of the repeal, that provision of law continues in effect for that purpose, notwithstanding its repeal by this act.
I got that. So, but that savings clause wouldn't necessarily work for this section because we're not proposing to repeal it. We're proposing to amend it, right? By simply taking out municipal court. Right?
So I guess, yeah, if you're technically right, I guess that maybe
so that's the kind of thing I'm a little concerned about whether
maybe we could change the word repeal to revise,
or we just leave this one alone. And the fact that it remains in the statute means that it gives the word weight, so that, and then it makes sense because it's for benefits that can be vested or can be continued through either beneficiaries. There could be other trust devices that come along in the next 50 years. So I just think we do, we adopt how Commissioner Rubin said, in this particular case, it is not broken. And we would be streamlining the statute so that it read consistently with other changes, but that is, it is not helping in this particular section. So
it sounds like you're saying let's wait.
Let's leave it alone.
My inclination would be, unless we take the time to develop a savings clause that would be applicable in this situation, my inclination would be to just leave it as it is. Down the road, if someone determines that there's no former muni court judges or their families that are benefiting from this, and they can take the reference out. Having the reference as a sort of anachronism doesn't bother me that much, and I particularly because it's benefits that affect individuals and families, and potentially families and stuff. My inclination, I'd rather have something left kind of annoying in the law rather than potentially mess that up.
Yeah,
I guess we might.
And there could be, honestly, there could be trust devices that make references to benefits you know, that have been earned because of serving as a municipal judge. I would leave this alone because I think it could have consequences that we never intended or contemplated that would be impacted by this change, and for no other reason other than just because we were doing a good job with revising the way that it read now. I don't think it's worth it.
I guess if you folks don't feel like there's a way to craft a savings clause that would protect vested rights, then that's the only thing we can do, because even doing like a 50-year sunset or calendaring this out for, you know, the commission's agenda in 50 years, like we'll still have the same problem at that point. We'll, you know, it's sort of impossible to ever know, okay, everyone is definitely dead and their trusts have all, you know, expired, and, you know,
yeah,
you basically never know.
We won't know. And I think if we made a reference to a savings clause, then people would consider, is this a repeal savings clause? And then even though if we rewrote it, I mean, you just have the issue that you have now, which is actually makes this commission pretty interesting. We have a mix of people who are not necessarily practicing and people who are not lawyers. So that's how the law should read. It should make sense for everyone. And if it's, I think we run the risk of trying to, or of creating more confusion if we craft a new savings clause. Not worth it. We just leave it as is.
Jane has her hand up.
Jane,
Sorry. Yeah, I agree. I think we should leave it alone. My concern is whether this would be viewed as substantive because we're dealing with vested rights for people. I just, crafting a savings clause would be kind of tricky because you have other parameters that are in play. So I'm in agreement. I think we just, you know, take a pass, wait, you know, if it comes back up again as something that really needs to be addressed, of course, then we can get input from legislators and other people on that. But I would concur with what I'm hearing from the other commissioners at this point.
Barbara, are you okay?
I am. Is Commissioner Kuba still with us? I just need to keep track of votes.
I don't see her.
On mute and her screen is dark.
Okay.
I suspect she had stepped out.
Because we haven't had a break and the meeting is kind of long, so
yeah.
I think we have a quorum though.
Yeah, we do.
Oh yeah, no, it's just I need to record whether she's present when the vote occurs. So the next one is section 53214.5. This relates to county deferred compensation plans. It's somewhat similar to the provision we just discussed, but Los Angeles County Superior Court says that it's still necessary for their purposes and that they believe there are other counties that also still rely on this particular provision. It does include a reference to municipal courts, like the provision that we just discussed. However, in this section, it may be possible to just delete that reference, because what the section does is it gives authority to participate in a deferred compensation plan, and says that the judges and officers and attaches of a court may authorize deductions to be made from their wages for the purposes of participating in the deferred compensation plan. There are no municipal courts anymore. Nobody is getting paid as a municipal court employee anymore. And so it doesn't seem like having a reference to deductions from wages for a municipal court employee is still something that would have any ongoing relevance. And so there's a proposed amendment on page 23 of the memo to delete the municipal court reference.
Barbara, are you saying that we can actually delete municipal courts here without disinheriting anyone?
That's my impression. I mean, I you know, as best I can tell,
that makes me so happy.
shouldn't have any impact. If it would have an impact, I think probably you might find that out by testing it with a tentative recommendation.
And then the one remaining municipal court employee somewhere in the state will pipe up.
Well, I don't think there are any. So
no,
me neither.
But what could happen is if there were rights, like creditors' rights for checks that or pension payments that may be due to a municipal. See, I'm listening to some ageism there. So cut it out. I'm in that group.
Well, if they've been abolished as an employer, then that no one can have their wages existing from an employer that doesn't exist. So no disrespect, but
pension rights. If they have pension rights that are attached to a municipal employee, so you never know. Okay. But I'm with Barbara. I think you just test it out with the tentative just to see if there's any objections. We should be fine.
Is there anybody who feels differently? Any abstentions? Okay. All right. Then the last category, we've now discussed all of the provisions that were in the 2001 tentative recommendation relating to judicial benefits and figured out how to handle those for purposes of a tentative recommendation. I did look for other statutes relating to judicial benefits that might contain some material made obsolete by trial court restructuring. In particular, there are some statutes in the parts of the code that relate to the judges' retirement systems, both JRS 1 and JRS 2. Some of those provisions refer to counties, and before the Sturgeon line of cases, it was, seemed like a possibility that the references to county payment of judicial benefits might not have survived trial court restructuring. I think now that the law is pretty clear on that point, and that counties can pay supplemental judicial benefits, probably the best approach is to leave the references to counties alone in JRS 1 and JRS 2. Does anybody have any different thoughts on that point? Okay, and then the other set of provisions are the ones in JRS 1 and JRS 2 that refer to the municipal and justice courts. And some of those are ones that, these again pose the same set of options that you just discussed. And some of them are ones that you could outright repeal through a sunset provision. Other ones are ones that you'd have to maintain two provisions in the codes, one that refers to superior courts and one that refers to superior municipal and perhaps also justice courts, depending on the particular provision. So, these are ones that you could either just defer the cleanup to a later date, like you just decided with the other provision, or you could use the sunset clause approach, and savings clause coupled together, at least for the ones that it would be possible to actually repeal rather than amend.
I guess my inclination is on sections that relate to potentially long-term benefits, which JRS is. My inclination would be just defer and get up at a later date.
I agree.
Is that unanimous?
Yeah.
Okay.
Yeah, it's unanimous. You're good. Right, Commissioner Padillo, or no?
Yeah, I'm fine with it. As long as we're on the subject, let me take a minute. Madam Chair, you made an offhand comment a minute ago about ageism, and I'm hoping that you were kidding. And I'd like it if you noted for the record that you were kidding, so we don't wind up in the newspaper as one of us accusing the other one of something.
You're right. It was completely jocular.
Yep. No problem then. Yeah, let's defer. I really don't want to disinherit anybody or cut off, unanticipated benefits. It's, this is a cleanup thing. Yeah. If it's a problem, let's defer.
Very good. And Commissioner Cuevas, did you just join us, or have you been listening in?
I've been listening in. I apologize. I had someone at my door that's the meter reader for LADWP.
Okay.
I've been a little busy. My apologies.
No, it's okay, because we noted you as absent for 1 vote. So I just wanted to make sure.
Yes, that's fine.
Okay,
that's fine.
Okay.
Yeah,
okay.
yeah.
Okay.
All right. Go ahead, Barbara.
So I think we're at the end of this memo, except for the commission had previously decided with regard to the work that it's done on representation and indemnification statutes that had material that was obsolete relating to trial court restructuring, that you wanted to combine that material in a tentative recommendation with other material on trial court restructuring. So I am kind of been assuming that you would probably want to take this, the decisions you've made relating to judicial benefits, the decisions you've made relating to representation and indemnification, the technical revisions that we discussed in connection with the memo on the Superior Court references, and put all that material together in a single tentative recommendation. Is that the sense of the commission?
Yes.
Okay. And then for the next meeting, we still have some issues relating to representation and indemnification, which I will bring back to you. I think probably I will not prepare a tentative recommendation for that meeting, but maybe for the next one. So I think that's it on those memos.
Brian, you're up for the next memo, but I know we went through and we didn't have a break. Would the commission be in favor of tabling this particular final item?
It depends on how long Brian feels he needs to do it. We still have 20 minutes.
Yeah.
Would it help to take a break?
We could take a break for 10 minutes, but then we would be, Brian, you'd have about 11:50 through 12 or go over a little. Did you guys want to do that?
I'd rather get through the agenda item. So, since we have it up, I'm good without a break. But
I think I could present it in 15 minutes.
Do it.
All right. Do you guys want to take a meeting break, or do you want to just push through?
Push through.
Commissioner Carrillo wants a break.
No, I'm fine. Let's go.
Victor,
yes, push through. Push through.
I will try to use the voice that Angela Donlan used earlier in the meeting, the high-speed squeal, to condense this as much as possible.
Minnie Mouse, yeah.
Yeah, so first of all, I want to apologize. I made a couple of dumb numbering errors in this memo, and I'm going to correct the memo and re-upload it. In the title, this is not memo 2020-32, it's 2021-32. And then there were 2 references to a former memo that laid out sort of the foundational law in this area. And I referred to 2020-54, it should have been 55. So I hope that wasn't a problem for anyone who went back to look at that.
Oh, then I'm done.
The commission previously decided that it was interested in continuing work to develop a statute that would require that when an administrative subpoena is served on a communication service provider to obtain customer records, that it would also be required to serve notice of some kind on the customer, so that the customer would have actual notice in time to move to quash the subpoena before it operates, and that is grounded in Fourth Amendment requirements. The case law we discussed before makes clear that the reason you need probable cause to support a warrant is because a warrant operates by surprise and immediacy and intrusiveness. Somebody shows up and says, I'm here to search. A subpoena gives you a reasonable amount of time to seek judicial review of the subpoena before you have to turn any records over, and therefore it's only required by the Constitution to be reasonable. Now, that's perfectly fine when the subpoena is served on the person who possesses the records that are being requested. It's a problem if you serve the subpoena on a third party who holds the records on your behalf. Because if you aren't also given notice, then you may never know that your records are being obtained, and you won't know that you need to act to contest the reasonableness of the search. So that's why we are looking at requiring customer notice when a subpoena is served on a communication service provider. And as the prior, yes, Richard.
Just to being one of the non-lawyers here, what is an administrative subpoena as opposed to some other kind of subpoena?
It's used by a government agency as part of its investigative power. So it's not like a subpoena but used by litigants in civil litigation.
Okay.
It's outside of any kind of court case. It's like if the Department of Real Estate wanted to get the records of a particular realtor in order to investigate whether they're in violation of the law that regulates realtors. They'd use an administrative subpoena for that. Huh. So it has it's government, which is why it's before us. So and therefore it's subject to Fourth Amendment protection.
Okay. So, but it doesn't require a court or anything to approve the subpoena?
No.
Huh. Okay.
No, just after the fact. If the person who's served wants to contest it, they have standing to contest it, and then a court will review it before it operates.
That's also true for what you're thinking of, Richard, the standard litigation subpoena. So if you're suing me, you can subpoena things from me, and I can later contest it in court, but you don't have to get a judge to sign off on your subpoena first.
Right.
And
it's different from a warrant.
Okay. And even if a court hasn't approved it, if someone serves a subpoena on me in the absence of any other intervention, I'm obligated to give it to them?
You can challenge it. Yeah. You can move to quash, but if you have no objections to it, then everything happens outside of the judicial process.
But the important part about this issue is that it's going to third parties, not to you. So
I got that. Yeah, no, that's
and so it's standard under Code of Civil Procedure that when a third party in litigation gets a subpoena, there has to be a notice to you, and that's what's absent from the administrative subpoena.
Yeah. Okay, got it. Okay, thank you.
And the notice to you is to allow you to move to quash it.
Yeah, but it's important for you to realize too that some agencies might just turn over the documents, and others might be very vigilant in protecting people. So you are very right, and I raised my eyebrows when you said it, because it is very natural for this to be, the process, because it is scary a little.
Yeah. Okay. Thank you.
In the memo that presented this general issue at the last meeting, I noted that there is a statute in existing law, the California Right to Financial Privacy Act, that regulates government access to customer records in financial institutions. It's been the law since the 70s, and it includes a provision that requires that an administrative subpoena be served on the customer if the government is trying to seek their records from a financial institution. So that was provided as an example of an existing law that follows the approach we're contemplating. So the point of this memo is that I was looking more closely at the California Right to Financial Privacy Act to see the extent to which we could use it as a model for drafting the proposed law in this study. And that's what the memo discusses, is that possibility. And just to move fairly quickly through it, the core provision of I'm not going to remember the acronym, the financial institution statute is Government Code Section 7474. And as I point out on page 2 of the memo, subdivision A of that section is the provision that requires that that when you're seeking records from a financial institution pursuant to an administrative subpoena, you must serve a copy of the subpoena on the customer. And it provides some related law about what has to be in the subpoena, and also that 10 days have to pass before you actually try to obtain the records. And that's to provide a reasonable amount of time for the customer to respond. One thing I noted here, the statutes refer to an administrative summons or subpoena, and I don't know what an administrative summons is. I wasn't able to find any other reference to that in the California codes. So if anybody out there listening knows what that means, please contact me offline because it would be helpful to know. And then 7474C is a related provision that says that a financial institution is free to notify its customer on its own initiative if it receives an administrative subpoena seeking the customer's records. And 7474D provides that a motion to quash an administrative subpoena used in this way is to be given court priority. And I've identified those as sort of the core relevant provisions from this act. And it's my recommendation that we include similar provisions in the proposed law that we're drafting. So if anyone has any concerns about that, now would be the time to hear about them.
No.
Okay.
Makes sense.
Any no's or abstentions? Don't see any. Thank you. And then I mentioned a couple of related provisions that are also in the Act, but not in Section 7474 that seem relevant to me and should probably also be included. The first is Section 7070B, which provides that a financial institution that receives an administrative subpoena seeking customer records doesn't have a duty of inquiry beyond looking at the face of the instrument. They don't have to determine whether or not the government agency abided by the requirements of this act. And I think that makes sense. The role of the institution in this process is sort of ministerial. They don't themselves have a stake in it. And it wouldn't be fair to create an implication of liability if the government agency didn't follow the law, that the bank could be held liable for that, for breaching some duty to inquire into whether the government agency abided by the law. I think it's reasonable to allow them to rely on the face of the instrument, and that's what that rule says. Subdivision C of that section requires financial institutions to maintain records of government access to customer records for 5 years and to make them available to the affected customer on request. And I think that's reasonable too, to create a record that will persist long enough that if there's some kind of subsequent litigation, the customer can access information about which agency received their records, when, which records, that kind of thing. And both of those provisions seem like they could be translated over into the context that we're studying, which is a subpoena used to obtain information from a communications service provider. Does anyone have any concerns about including provisions like that in the proposed law?
No.
Okay. There is an issue that I raise on page 4 that is not addressed by the financial institution statute, but that I recalled from my prior work. Thank you, Victor. I just received an email educating me about summons versus subpoena. I'll take a look at that later. I know from my prior work looking at the Federal Electronic Communications Protection Act that there are provisions that are aimed at avoiding spoliation of evidence. When you're dealing with electronic communications, a customer's email, text, files stored in cloud storage, etc., if you give that customer notice that they're going to have to produce those records to the government unless they successfully quash the subpoena or limit it, there is a possibility that they're going to alter or destroy those records because they have access to them. I think that's not addressed in the financial institution statute because it's not parallel. I don't think a customer at a bank can go in and modify or delete records of their transactions with the bank. The bank controls that information exclusively. But that's not the case with electronic communications. The customer has access to delete or modify those files. Now, I know that there are going to be providers who also maintain archival backups that aren't under the control of the customer necessarily. But there's nothing that I know of in the law that requires that. And as I point out in the memo, there may even be companies that advertise and market the fact that they don't do that. Because I know there are communication services aimed, part of what they sell is the ephemeral character of the communication, the fact that it won't persist. And so it may be that there are providers who would keep these backup copies, but we can't rely on them to do that. So the possibility that I'm raising in the memo is borrowing a page from the federal statute that would allow the state agency, when it serves a subpoena, to request that the communication service provider preserve the evidence pending any kind of litigation over the validity or extent of the subpoena, to prevent the customer from deleting or modifying their files before the subpoena can operate. Does everyone agree that that would be a good idea? I see a hand up from Richard.
Yeah, just a question. So I've seen in the memo, request means obligate.
Yep.
Secondly, is that going to impose potentially some new cost on the provider that they may not be in a position to comply with?
Yeah, and the federal statute expressly provides that the government is obliged to reimburse that cost. And I would propose that if we pursue this kind of option in our statute, that we do the same.
Okay.
I think
and this is the first time I'd ever heard the word spoliation. I got it. That's a new one on me.
Brian, the change is pretty substantive.
Yeah. Well, we're not barred from doing substantive reforms.
No, but this is huge, though. This is huge. Because if you are an organization that stores documents in a cloud and it's set for X number of days, I like this from a consumer standpoint. I absolutely do. But honestly, I think as a commission, us making or borrowing this from another statute to create rights and obligations on businesses, this is a big one.
Well, it would be for the purposes of a tentative recommendation, and they could let us know if they have concerns about it. I think that, I think this is going to be salient because, there was the recent scandal about the Federal Justice Department using a subpoena to obtain communications metadata from sitting Congress people without their knowledge. And our statute would prevent that kind of thing. And
no, I said from a consumer standpoint, I love this.
Yeah.
But then with the business hat, I just know that when, I was general counsel for trying to protect and preserve employee records alone, that I know that this would have been a very big cost, and it would have required probably hiring a new person to deal with this, because then you have to also figure out how to get any type of to offset the costs. I mean, this is big, and I just think that we need to weigh the fact that this is a very substantive change.
I hear you. I saw that Commissioner King had his hand up. And
I'm just wondering, I'm sympathetic and I would like to do this, but I'm thinking of email services like Signal and I think Tiger Email that you set the email and the data to expire after 20 minutes automatically. How would that interface with companies that have that sort of business model? I
don't think it would affect them much. Because, if the communicate, nothing stops somebody from barring some sort of compulsory legal process. You can choose to delete your own messages in order to be opaque. That's just your choice. And if there's a company that facilitates that as their business model, like your communications will be ephemeral, that's their choice. A subpoena can only affect records that exist. So if you were talking about something that deletes within 30 minutes and they got a subpoena saying we're trying to get this person's communication,
Right.
and we order you to preserve their records, I think that that order would have prospective effect, and it would capture whatever it captures.
Okay.
Commissioner Creel?
I share some of the current concerns that have been raised. I have a specific question, again, borrowing a phrase from another context in Public Records Act requests aimed at government entities. One of the guiding principles is that the entity that holds the data isn't required to create a compilation.
Right.
So, so that sounds consistent with what you're saying, that, a company like Telegram or Signal or Proton Mail wouldn't be required to write a new algorithm to capture your messages going forward and override, the user settings that they expire after a certain amount of time. But it could be read that way. And, if I were general counsel for a technology company like that, when I get one of these things, now I have a concern about potential liability for the company that our very business model would expose the company to liability for spoliation, because now we're on notice that we're required as part of the process to capture that stuff, even though we're not set up for it, and even though usually we wouldn't have to go to some expense to create a method for doing that, but now the company is potentially exposed. So I would be worried about that.
In the interest of keeping to my 15-minute prediction, since we're just talking about this at a conceptual level at this point, we don't have language, how about I bring back a fuller discussion of this particular issue for a future meeting, and hopefully we'll get some industry input as well. Is that okay?
Yep.
Yeah.
I would totally be in favor of that, because I understand the concerns about cost, but I'll be honest, from a consumer protection point of view, this to me seems like an important thing to do for us to examine, and it may be when you come back with that, if we get to the point of a tentative recommendation, then we'll be able to solicit some real life scenarios where how does this really impact people? I mean, we can do it, but federally, we already have, there's already a statute that has all these. So, the question is whether California wants to follow the federal rule.
So the last two items in the memo are items that I've flagged.
So Brian, if I can also just, so not only bring back language, but I think if you could also do some research on just any legal or case law that pushes back on something like this being adopted, because I am concerned that it is something that maybe the legislature should look at, and I think we may be exceeding our scope with adopting something like this.
Yeah, I will bring back a discussion, and I will take a look to see if there's federal case law on this, although as Commissioner McAllister correctly said, it's existing law at the federal level, so they must be making it work somehow.
Yeah, that's good.
Okay, so the last two items are things that I think probably should not be included, but they are in the financial institutions statute. So I'm flagging them as items of existing law that I think maybe should not be ported over. First is that the financial institutions law includes this provision 7471A, which is about voluntary disclosures to government by financial institutions when they believe that a crime is occurring. So there is a statute that lets them do that. If they see evidence of crime, they can notify the government on their own initiative and provide evidence from the customer records on their own initiative. As I point out, the California Electronic Communications Privacy Act, CalECPA, which was a recent enactment, already has provisions that recognize that a service provider can voluntarily disclose information so long as it's not prohibited by other law. And those provisions, which I set out on page 6, specifically address how to handle such a voluntary disclosure when it relates to evidence of crime. And so I think that issue is kind of ancillary to what we're looking at, which is, should the customer get notice, right? The question of whether a service provider can voluntarily approach government to provide evidence of a crime, to my mind, doesn't have a necessary connection to the issue that we're looking at. It's a real issue. It's just not this study, I don't think. So my inclination would be to not include it, not try to address it. The CalECPA already does so, and presumably that's what the legislature wants in terms of how to handle that. Does anyone, okay, I see one thumb. Everyone okay with that judgment? Okay, thank you. And then the second issue, even more so, court-approved disclosure without notice to the customer. The California Right to Financial Privacy Act includes this provision, 7474B, which allows the government in very narrow specified circumstances to request that the subpoena be served and operate without notice to the customer in contemporaneous with the disclosure of records. The notice is postponed. And it has to be an investigation of the Attorney General or the Commissioner of Business Oversight enforcing laws within their jurisdiction, or a county district attorney enforcing antitrust law. I'm not sure what that's about. And if it's that kind of an investigation and the government can demonstrate a reasonable inference that a law subject to the jurisdiction of the petitioning agency has been or is about to be violated, they can postpone notice to the customer. I would recommend against including this kind of a postponement rule in our proposed law. I don't really know what it is about those particular kinds of investigations that the legislature felt required this treatment. I could go back and try to dig through the microfiche from the mid-70s to see if I can find legislative history on this. But it may have been something special about the kinds of investigations they were contemplating that I don't think would necessarily apply to a person's general population's email, etc. The other thing is that this, to my eye, runs counter to the authority that sort of forms the foundation of this particular piece of work. It was my sense from the case law that we examined that you're not supposed to obtain a general search warrant on somebody without probable cause. You're not supposed to be able to search their records immediately and intrusively without their knowledge, without prior judicial review, unless a court finds that there's probable cause. And the reasonable inference standard here is not a probable cause standard, and I expect it's lower. And so I would feel uneasy about building a rule like this into our proposal because it seems to cut strongly against the grain. It is going to be a tentative recommendation, and we can specifically flag this question and see if we can get public comment on why such a rule should be included in our proposed law and why such a rule would be constitutional. I think I would like to know more about that. So that's my recommendation, is that we not include this provision, but that we flag it for comment. I'm seeing 2 yeses. Anyone see it differently? Okay.
I'm worried. I do think it is substantive. I really, really do.
But Crystal, we can do substantive reform.
No, what I'm saying is you're changing a lot about the law and how things work in civil law. So I am worried about this because it's not so much as like, tweaking it. We are making the law better for consumers, but honestly, that exceeds the scope of this commission. We're not to change the law.
But Brian is flagging it for comment. We're actually not changing anything.
No, I know. We're flagging it for comment, and I'm okay with doing that if we flag it for comment that lasts for at least 6 months, because this is a sweeping change.
Well, we'll get there when we have the tentative recommendation, and we may hear from groups before then. I
can tell you this as a business, the civil law allows for flagging of embezzlement and schemes that business owners have no clue are going on, but these statutes allow for notice. So, or notice to the victims of certain schemes. So I am worried about this change, but I do get it, like you said, currently with looking at how some of the federal investigations have happened that have been just, completely scurrilous. I'm okay with the end result, but I do think we are making legislative changes, and that is I'm not comfortable.
This is definitely towards the heavy end of policy work. But again, this was prompted by a specific assignment from the legislature, a statutory assignment.
No, and I agree with it. It did need change. This statute needed a lot of work, and people do rely on this that because there's nothing in writing for a lot of different other organizations and businesses. So people look at this statute a lot. Like I said, I'm okay with it if we create a longer than usual comment period because of COVID and because it could go under the radar of many groups that need to say.
Could we maybe make that decision when we have a draft tentative recommendation before us? Because I think that we might hear from people comment that might give us more comfort.
Okay, I'm not going to vote in favor of this, so I'm going to have an objection. Yeah.
You want to vote?
We can take a vote.
Okay. I mean, the other thing, Commissioner McAllister, you've had your hand up.
Yeah, I just wanted to say that I think it'd be worthwhile to have our legislative council person weigh in on this a little bit, but I don't think that anything precludes us from going ahead and moving forward with the strategy that Brian's outlined. We're not actually, changing the law right this minute, but we are tasked with examining it, and I think it's worthwhile to throw it out. And then, maybe down the road there'll be a determination that we should do it differently or not do it. That's fine, but I mean, this is just the initial. I hear you, Commissioner O'Brien. I mean, I'm not trying to discount what you're saying at all.
I appreciate it.
I just think we need to take some action, sort of make a foray, see what happens, get some input from Ledge Council and from other entities and see where we go with it.
Yeah, because I'm not comfortable, minutes after we've gone over, and this memo is not that, it's not proposing little technical changes. We're doing a lot of work here.
So should I record you as an abstention or a no vote?
No, as a no right now.
Okay.
Well, but I think Commissioner McAllister has made a good point. If we could, I'd like to see someone weigh in. I'd like Kara or, legislative council to come back. I think Senator Chow's office was on the line, or somebody person.
They were.
Yeah, they left.
They left. Okay. So yeah, I'm not comfortable with making a vote on this.
Okay. I've got you as a no.
Okay.
But the decision of the rest of the commissioners present here is for me to bring back and further develop language based on the proposals made in this memo. Yeah.
I would vote on that. I'm okay with that, Brian.
You're okay with that?
Yeah, but I don't, want to make a change. So no to that, but
all right,
further developing it, yes.
I'll record that as the decision that the commission wants me to work further to develop a proposal based on the recommendations made in this memo.
That's good.
Okay. I don't have anything else.
Okay, we did it. We concluded. We'll go ahead and call the meeting then. The meeting is concluding. Are there any questions right now or any issues from the commission?
When's our next meeting? Are we going next month in July?
Yeah, I believe so. Hold on just a second. I'll get it. July 22nd.
Is that a good date for everyone? Okay.
Yeah, I was just thinking, like, at some point, and this is across that bridge when we come to it, but the governor's decision about whether we have to go back in person could affect whether we stay going every month or go back to every other month.
Yeah, definitely.
But table that.
Yeah, no, that every other, this last month was helpful. Don't you agree, everyone? Because it is, it's kind of hard.
Yeah.
Yeah.
Although we are only doing like 3-hour meetings instead of 6-hour meetings. So
That's true.
all right,
Perfect.
we'll cross the bridges as we come to it.
Sounds great.
Thank
Thank you.
you, everyone. I'm
See
gonna
everyone. Thank you,
end the-
everyone.
Thanks a lot.
Bye.
Bye.
Safe.
Bye.